As of May 2025, ICE seems to have expanded the definition of what we previously knew to be expedited removal. They are targeting a larger body of people with expedited removal proceedings, which means that if you're an alien present in the United States in removal proceedings, they're having the immigration judge dismiss those proceedings so that you could be detained and be removed from the United States. Now, it is important to understand who is subject to expedited removal. It will be two categories of people. Those people who have entered the United States and had their initial CBP encounter within 14 days of their entry, or within 100 air miles of the border. And the second category of people would be aliens who have not been continuously present in the United States for at least 2 years before a finding of inadmissibility by ERO. Now, the expansion of expedited removal rule and the practice of it is being challenged in federal district courts. However, until there is a clear ruling on it, it's important to understand that there are ways to avoid being subject to expedited removal. If you're between these two categories of people who have entered the United States within 100 air miles and have not been present in the United States for at least 2 years before immigration proceedings have started, perhaps avoid going and attending the immigration court proceedings in person. So what you would do is file a motion to appear by WebEx. And if you do not know how to do that, contact a competent immigration attorney who would assist you in preparing a motion to appear by WebEx for your immigration court proceedings, so that you don't have to have a physical encounter with ICE if you're a potential subject of expedited removal proceedings. What you should do if you're a pro se respondent present without an attorney is oppose that dismissal. Ask them to make it a part of record that you would like to file an appeal with the Board of Immigration Appeals and proceed with filing for a motion to reconsider, or at least an appeal of the immigration judge's decision. However, for pro se respondents, so if you're a person who's present in the immigration court without an attorney, that should really trigger the judge's duty to warn you of the potential detention and expedited removal proceedings that will follow upon the granting of the motion to dismiss by DHS. And if you were not given that warning, then there might be a chance to appeal the dismissal decision based on the fact that your consent to the dismissal was not intelligent and not knowing. If you are a person who's subject to expedited removal proceedings, but you were not detained in court, and neither were your immigration court proceedings terminated or dismissed, but you're detained outside of the court setting and you're subject to expedited removal proceedings in ICE detention, what you should do and you must do is you should ask your removal officer to have a CFI, a credible fear interview. Now, it doesn't make a lot of sense because you would assume that if you've already lodged an application for asylum, an I-589 with the judge, the ICE officer should know that you have a fear of returning to your home country. But if you do not have an attorney by your side and you're in the unfortunate circumstance of being placed in expedited removal proceedings, it will be very telling if you advocate for yourself and consistently ask for a CFI, a credible fear interview, over and over again before your expedited removal is actually executed. That may be your last and only chance of any relief from removal or deportation from the United States. If you are a person who may be subject to expedited removal, it would be very beneficial and telling to obtain or at least engage the consultation of an immigration attorney who may be available to promptly respond to your need if one arises once ICE has decided to execute expedited removal proceedings against you. So then an attorney can step in on your behalf, communicate with ICE, argue for a CFI interview, and oppose dismissal of your removal proceedings.